Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss the case of Arnesh Kumar versus State of Bihar and others. It is listed as number 66 in the list of AOR leading cases, and DK Basu and Arnesh Kumar often are read together because both of them are dealing with the guidelines on arrest or rights of arrested person. Now, when the difference that arises in both the cases is that DK Basu is majorly talking of rights of arrested person because in that case, the prominent issue that was raised up was the custodial torture and custodial deaths that was happening at that time, even with the under trial prisoners. But coming forward to the case of Arnesh Kumar versus State of Bihar, this case is laying guidelines on how an arrest can be made. Okay, so one is dealing with post-arrest effects, that what are the rights of arrested person, and another Arnesh Kumar 2014 judgment. It is dealing with how an arrest can be made, what are the guidelines under which what are the guidelines under which a person can be arrested. So this particular case is dealing with section 41 and 41A of the CRPC, which is talking of arrest. Okay, so section 41 of the CRPC is basically talking when a police officer may arrest without a warrant. Now, what is happening in this case? Coming to the facts of this case, what is happening in this case? I am using the SEC PDF for the discussion herein. Now, what is happening in this case? A complaint under Section 498A has been filed. Okay, so there is. There is this Arnesh Kumar who is accused, and his wife files a complaint under Section 498A of the Indian Penal Code, which basically deals with cruelty done by husband or the relatives. Now, this Arnesh Kumar gets arrested without any preliminary inquiry, without any notice, and he went to the court arguing that Section 498A is being misapplied here, and people are arresting people mechanically without applying their might. Now, the question that arises before the court herein is that do police officers have unrestricted or unfettered power to um, arrest a person under the allegation made on the basis of allegation made under Section 498A, or any mechanism can be devolved to test or any mechanism can be devolved to maintain a check and balance on in the cases of 498A especially. So now court herein is specifically dealing with section 498A cases, and court herein is also discussing how section 498A is often misapplied in the modern times. Now police just goes and arrests the person on the mere ground that there is an allegation of 498A without any decent proof. This is an observation that Supreme Court itself is making. And the court herein is also emphasizing that no arrest can be made in a daily basis manner or a routine manner or something very casually, and police officer cannot arrest a person without reasonable or credible satisfaction after some investigation. Now court herein, of course, allowed the bail to the appellant and overturned the rejection of anticipatory bail by the High Court. But however, the court herein is also it is also laying down some kind of guidelines that needs to be exercised by police while making an arrest under Section 41 of the CRPC. Now these guidelines stands like herein. So first guideline is with respect to Section 498 or A of the IPC or Section 4 of the Dowry Prohibition Act. And it is saying that all the state governments hereby are mandated to instruct the police officers not to automatically arrest when a case under Section 498A is filed or Section 4 of the Dowry Prohibition Act is filed, but also in those cases in which offense is punishable with the imprisonment of term which may be less than 7 years or which may extend to 7 years with or without fine. is registered, but they need to satisfy themselves before the necessity of arrest, as is flowing from the section 41 parameters. Now, all the police officers are required to take the checklist containing in the specific sub clauses of section 41 clause 1, which are the police of section 41 clause 1 b 2. Now the police officer shall forward the checklist duly filled and furnished with reasons and materials that necessitated the arrest to the magistrate for further detention and while producing the accused. Now the magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in the terms aforesaid, and only after recording its satisfaction the magistrate is going to authorize the detention. Okay, so the detention not to arrest an accused, the decision, pardon me, the decision not to arrest an accused shall be forwarded to the magistrate within 2 weeks from the date of institution of the case, with a copy to the magistrate, which may be extended by the superintendent of the police or the district of the police of the district for the reasons to be recorded in writing. Right now, the notice of the appearance in terms of section 41A, which talks of serving of the notice, should also be served on the accused within 2 weeks from the date of institution of the case, which can also be extended by superintendent of the police of the district for the reasons to be recorded in writing. Now, this case is basically strengthening the argument that arrests cannot be made just automatically. A checklist needs to be provided to the police officers. Police officers are need to go through the checklist. They have to tick the checklist before arresting or not arresting. And while the police officer feels that there is a necessity, there is a reasonable satisfaction, then in that case the police officer is required to forward that checklist to the magistrate for further detention, which shall be confirmed by the magistrate itself after going through or perusing the material on record, right? And also, if the decision is such that accused need not be arrested, that also has to be has to be forwarded to the magistrate. And if within 2 weeks, but if there is extension needed, the superintendent of police may further extend it. Now, notice has to be served on the accused in the terms of section 41A of the CRPC, and section 41 clause 1 guidelines are needed to be adhered with. Okay, now section 41 of the CRPC lays down the guidelines when police officer may arrest without a warrant. Okay, so the police officer may arrest without a warrant if there is a cognizable offense being committed in the presence of him, and if there is any reasonable complaint or credible information that has been received by him, and there is a reasonable suspicion that cognizable offense is about to be committed, for which punishment is either up to 7 years or lesser than 7 years, then in that case the police officer may carry out arrest. But he has to be satisfied of the conditions, which are that he has the reasons to believe that such person has committed the said offense. On the basis of such complaint, information, or suspicion that is arising, there occurs reason to believe that the offense has been committed, and the police officer is satisfied that the arrest is necessary, that to prevent such person from committing the offense, further arrest is necessary, or to do a proper investigation, arrest is necessary, or to protect the evidences from disappearing. If there is a threat that if the person is not arrested, he will cause disappearance of the evidence or may tamper with the offense, and then in that case such kind of arrest can be made. If there is a apprehension that unless the person is arrested he cannot be produced in the court, then also the arrest can be made. So these are some parameters on which the checklist has to be marked, and if checklist is marked in such a manner that necessitates the arrest, then the arrest can be made by the police officer, subject to the fact that it has to be further sent to the magistrate. Whether you are detaining or whether you are not detaining, it has to be sent to the magistrate in either case. And if the case is of arrest, then in that case the accused needs to be produced before the magistrate as well, which will stamp his detention further. So this is the case of Arnesh Kumar versus State of Bihar. I hope the discussion was useful. Thank you, everyone. Please stay tuned with us. It is one case which is discussing the importance of freedom and how arrest bring humiliation to the person. So this paragraph is basically talking of the intent of why arrest should not be done in a very casual manner. Now this is it for the discussion. Thank you everyone for watching. Please stay tuned with us on Legal Darshan. Have a great day.